Absolutely, my lord. Because the law requires, my lord, that before you declare a winning candidate, you receive all envelopes, all DR forms from the constituency. The only exception that their lordships have created in this decision of Muzanira is if the results that have not come are officially cancelled. That was not the case. No, they were not. They were not cancelled. The returning officer simply proceeded to declare the winner without receiving all results from the constituency, my lord, as is the command of section let me begin with the law, my lord. Section 72 of the PEA, which their lordships in Muzanira were interpreting, which they were interpreting in the former section 58. Now it is 72(1). Now it is 72(1). It provides, my lord, that 72(1) says after all the envelopes containing the declaration of results forms have been received, the returning officer shall, in the presence of the candidates or their agents, or such of them as wish to be present, open the envelopes and add the number of votes cast for each candidate. You do not declare a winning candidate without all envelopes. Now, my lord, in Bamzanira, they said, of course, you can begin tallying. Okay, if there is, and that's also provided for in the law. You can begin tallying, but declaration, you do not do so until you have received all envelopes. I was saying that the exception, my lord, they created is of the decision, my lord. I'm at page 751 now. 751. I'll get for you the page of the exception, my lord. If they're not complete, my lord, that's all. If a constituency has 197 polling stations and you have results of 170 polling stations, they are provisional. Even that, my lord, even that, my lord, even that, my lord, which you have said, happened and is unlawful. First of all, what you have just said happened in this case and is unlawful. Okay? At the time of declaration, the results were different. At the time of gazetting, the results were different. In Muzanira, the Court of Appeal has said that is unlawful for the returning officer to do, first and foremost. This decision has told you once you issue a return form for transmission of results, you can't touch it. So, my lord, I only put the final declaration where that which you are saying. No, my lord. The previous results are, but that was not my point. The point was that because you do not have all 197 envelopes, DR forms, the only implication is that what you have declared are provisional results. I was, my lord, taking you to the exception that you had asked me. That same page, 751, where I am. Just below the second highlighted part, there, my lord, they are saying, unless they are cancelled. And the second respondent did not tell us that they cancelled. They did not.
They don't cancel implied.
And cancelling, my Lord, is not by implication. We appreciate, my Lord, after the second highlighted part, down there, after the second highlighted part, down there it says, we appreciate that there are cases where certain results may be missing or cancelled. And the available results are used to declare a winner. None of those applies to this case. They were not cancelled, they were not missing. So that's non-compliance, my Lord. So the law commands the returning officer to only, they were not missing. No, my Lord, my Lord, you cannot miss something that doesn't exist. This was a question of non-existence of that, not missing results. Missing results is this, that results have been declared, like in Nyakecho, Saropendi. Results have been declared, DRR forms have been filled along the way to the transmission. Then they disappear. The Court of Appeal has dealt with missing results. These were not missing because they were not there in the first place. So I'm saying this, therefore, does not apply to our case. And cancellation, my Lord, is, of course, you can't do it by word of mouth. Okay, there is a procedure, my Lord, if you want to cancel results. And the EC has not said, my Lord, that they cancelled. Not at all. Then the question, my Lord, would be, what does the law tell them to do? I've just referred you to the law. Postpone to the next day. Yes, the voting to the next day, my Lord. And how, because you see, my Lord, after the election is held, the law commands the EC to declare a result in 48 hours. They still had time. Yes, so they could have held the election again in those 14 polling stations. The next day, the law gave them that option, and they didn't take it.
Okay, 77. Okay,
now, my Lord, which brings me to the second limb of this issue, which is the issue of substantiality. Now that, my Lord, I have told you and I have given you authority and evidence that there was non-compliance with the provisions of the law, the next issue is whether that non-compliance affected the result of the election in a substantial manner. My Lord, I will begin with the decision of Kizza Besigye versus Museveni. We all know it's a very huge decision, but it's the excerpt I'm referring to is reproduced in the case of Bantaribu Issa Taligola versus EC. Besigye of 201. Bantaribu, where that excerpt is quoted, is at page 818. But the case starts at 793. Bantaribu Issa Taligola versus EC and Oronederi, 2021. The excerpt I'm referring to of Kizza Besigye is captured there. Page 818. 818 of the second volume. My Lord, is 818. That's where the holding is, but the case starts at 793. The case of Bantaribu Issa Taligola versus EC and Oronederi. Now, my Lord, permit me, my Lord, to refer to that excerpt. I will not read the whole of it, but towards the end, His Lordship was trying to explain what substantial effect means. He says, that means that to succeed the petitioner does not have to prove that the declared candidate would have lost. It is sufficient to prove that the winning majority would have been reduced. Such reduction, however, would have to be as to put the victory in doubt. What does that mean, then, my Lord? It means that in this petition, we don't have to prove, my Lord, that the winner would have lost or that the loser would have won. It is enough in this petition, my Lord, if we prove, and we have, that the number of people whose electoral choice was not ascertained by the Electoral Commission is greater than the margin between the two candidates, between the winner and the first runner-up. That is what we have to prove. Okay? I will have established substantial effect, my Lord, if I prove that because of this number of people whose choice we don't know, because nobody knows how they voted, is greater than the margin. My Lord, the margin between the first respondent and the petitioner is 8,881 votes. Those whose choice we do not know, but we are clear voted at the election, is 16,640 votes. They are almost double the margin. They are almost double the margin. 16,640. 640. But the margin, yes, I didn't get your question, my Lord. Yes. 14 polling stations. Yes, my Lord. The tally sheet? So, subtracting this from the... Yes, my Lord. Yes, my Lord, I have. Okay, they will do that, my Lord, as we go on. But you can also get... Okay, my Lord. But you can also get it, my Lord, from the tally sheet. The tally sheet gives you the number of registered voters per polling station and those who voted. If you look at the tally, it could be easier, my Lord, but even that they can do from here. But you can easily get it from the tally sheet. Okay. I'm obliged, my Lord. Now, what I was saying, my Lord, is that the margin between the winner and the first runner-up, who is the petitioner, is half of that number, nearly half of that number, at 8,881 votes. When she was here in cross-examination, I should probably also say this, my Lord, when she was here for cross-examination, and Mr. Baz took her